4:51 a.m. Conley Terminal, Boston, Massachusetts. January 9th, 2026. The loading bay was cold. Exhaust from a diesel forklift drifted under the sodium lights. A row of commercial refrigerators sat on pallets along the east wall, 12 units, each standing 6 feet tall, brushed stainless steel, the kind you see in restaurant kitchens from Portland to Providence. Customs and Border Protection Inspector Dara Nguyen walked the line with a flashlight and a clipboard. Routine pre-clearance check. 40 minutes until her shift ended. She had been on since 9 the previous evening. 7.5 hours of walking cold concrete under fluorescent and sodium light, checking manifests against cargo, running through the procedural checklist that most people in her position had reduced to muscle memory. She was not looking for anything specific. She was doing her job. She stopped at the 7th unit. The coolant line on the back panel had a seam that did not belong there. A ring of metal, faintly darker than the surrounding surface, about 2 inches in diameter, running along the interior chassis wall. Factory-sealed refrigeration units do not have interior welds. The coolant system is closed and external. There is no reason for a seam on the inside of the housing. She held her flashlight at an angle and looked at it for nearly a full minute. She ran her thumb along the circumference of the seam. It was smooth. The edges were finished. This was not a manufacturing defect or a shipping scar. It had been done deliberately by someone who knew what they were doing. She had been doing pre-clearance checks at Conley Terminal for 6 years. She had never seen this before. She flagged it. Wrote 3 words in the margin of her inspection form. Abnormal interior weld. Those 3 words would trigger 9 weeks of covert federal surveillance, a sealed warrant brief, and a pre-dawn raid that ended with agents prying open 12 commercial freezers on a Worcester loading dock. Inside, 267 aircraft-grade gyroscopes packed in shock-absorbing foam behind coolant plates, wrapped in polymer sheeting and labeled cold storage components. Destination: a freight forwarder in a third country port. According to federal prosecutors, the final destination was Iran's unmanned aerial vehicle supply chain. The front company was called Polar Crest Refrigeration Supply LLC. It had 5 locations across New England, a legitimate state license, a trade show exhibitor badge from a Boston convention, and a Little League sponsorship banner in a Worcester park. It had been operating as a covert procurement cell for restricted aerospace components for at least 14 months. Here is what the case file reconstructs. Polar Crest Refrigeration Supply LLC was incorporated in Worcester, Massachusetts, in September of 2024. Its registered agent was a man named Dariush Khorram, listed in state filings as a commercial equipment importer with prior experience in the restaurant and food service sector. The company held a valid Massachusetts commercial sales license. It paid its taxes. It appeared to be exactly what it said it was. Its 5 retail locations, spread across Worcester, Springfield, Lowell, Portland, Maine, and Providence, Rhode Island. Each carried working inventory of commercial refrigerators, freezers, prep tables, and related equipment. Walk-in customers could browse floor models. Sales staff quoted prices. Credit card terminals worked. The company had a functional website with a contact form and a delivery scheduling portal. The restaurants and cafeterias that bought from Polar Crest received legitimate equipment. Some units were assembled from parts sourced in the United States. Others were imported from overseas suppliers through standard freight channels. A fraction of each incoming shipment carried something else. The aircraft gyroscopes and inertial navigation modules hidden inside the coolant compartments were the core business. The restaurant supply operation was the cover. 5 stores, a trade show booth, a Little League banner, all of it existed to generate plausible commercial activity that explained the import volume, the freight bills, and the warehouse space. What stands out about this case is the patience. 14 months. Legitimate sales. Real customers. Real deliveries. The operation was not rushed. It was built to last long enough to move a very specific quantity of a very specific component. 267 gyroscopes is not random. That is a procurement order. Someone, somewhere, had a list. The customs inspector's flag went to a CBP supervisory officer at Conley Terminal that same morning. By 8 a.m. on January 9th, the supervisory officer had contacted the Boston Field Office of Homeland Security Investigations. By 11 a.m., a preliminary case number had been opened. What HSI did next would define the investigation. Special Agent Carolyn Meade drew the case. She had spent the previous 3 years working export control violations out of the Boston Field Office, a narrow specialty that most federal agents avoid. Export control cases are technical. They require understanding commodities lists, licensing thresholds, and dual-use designations. They rarely make headlines. Meade looked at the initial flag and recognized the component category immediately. Inertial navigation systems and gyroscopic components are on the Commerce Control List. They are export-controlled under the Export Administration regulations. Shipping them to Iran without a license violates United States export law. Shipping them in a way designed to conceal their nature adds conspiracy and sanctions evasion charges. Shipping them to support a foreign military program potentially elevates the matter to something far more serious. The first question, was this one shipment or a pattern? She contacted the Diplomatic Security Service. DSS handles export control violations that touch on national security and foreign government end users. Within 24 hours, a DSS special agent named Marcus Ellard was assigned as co-case agent. Only 3 people worked the case at this stage: Meade, Ellard, and a third agent from HSI's Trade Investigations Unit. The raid brief stayed sealed. 4 months before execution. The reason for that tight circle: if Polar Crest became aware of federal attention, the shipment pipeline would stop, the components would disappear, and the procurement cell would dissolve. They needed the operation to keep running while they built the case. Meade went back 14 months. She pulled every commercial import manifest filed under Polar Crest's importer of record number. There were 63 shipments. 14 of them included commercial refrigeration units arriving from a freight consolidator based in a third country port that the case file does not identify by name. The freight consolidator's documentation listed the goods as food service refrigeration equipment, standard commercial grade. Of those 14 shipments, the routing pattern was unusual. The freight consolidator was not a major commercial logistics provider. It had no web presence. Its registered address was a mail forwarding service. Its freight documents used an invoice template that differed from the standard international commercial invoice format in one specific field: the unit pricing. The cold storage components line on 12 of the 14 invoices was priced at 3 times the standard industry rate for the listed specifications. I went through those invoice comparisons line by line. The market price for the listed refrigeration components was publicly verifiable through industry catalogs. What Polar Crest was paying, on paper, bore no relationship to what was being described. You do not pay 3 times market rate for a standard compressor unit unless the invoice is describing something other than a standard compressor unit. The pricing gap was the tell. The challenge was building enough around it to justify a warrant. Meade and Ellard needed to demonstrate that the goods were mislabeled, that the concealment was intentional, that the routing was designed to evade export controls, and that the destination was Iran or an Iranian-linked end user. Proving the third element from outside the operation was the hardest part. They could not open the packages. Not yet. Opening one package without a warrant would collapse the case. They needed probable cause first, then execute simultaneously, everywhere, so nothing disappeared. 3 months of covert surveillance followed. The HSI and DSS team deployed physical surveillance on the Polar Crest warehouse in Worcester, located on a light industrial corridor in the city's southwest quadrant. They documented delivery schedules, truck movements, and personnel activity. They placed cameras on utility infrastructure near the facility, within legal parameters. They did not enter the building. What they observed: incoming freight arrived on a consistent schedule, always on weekday mornings, always in unmarked rental trucks from a single logistics company. Outgoing shipments left the warehouse in 2 streams. One stream went to Polar Crest's retail locations, normal commercial deliveries, tracked to known restaurant accounts. A second stream, smaller in volume, left on a different schedule, different trucks, different routing. Those shipments went to a commercial storage facility in Providence, Rhode Island. The surveillance log from those first 3 weeks runs to over 400 individual entries. Agents recorded the license plate of every vehicle that entered or exited the Worcester loading bay. They noted the duration of each stop, the number of individuals present, the direction of departure. On several occasions, a rental truck would arrive in the morning, unload freight through the rear bay door, and depart within the hour. But on 3 occasions during the first month, a second vehicle, a panel van, would arrive within 2 hours of the freight delivery. The panel van never went to the retail locations. Its routes led south and east, toward Providence, always taking secondary roads, never highway corridors where commercial vehicle inspections are more frequent. Meade noted that routing choice in her case journal. It was a small thing. It was the kind of small thing that stops looking like coincidence after it happens 3 times in the same pattern. The Providence facility was leased under a different company name. A limited liability company incorporated in Delaware 2 months before Polar Crest was incorporated in Massachusetts. The Delaware LLC had 1 registered member. The address on the operating agreement was a residential property in Framingham. That property was registered to a man named Yusef Arvaneh. Arvaneh did not appear anywhere in Polar Crest's public filings. He was not the registered agent. He was not listed as an officer. He had no visible connection to the restaurant supply industry. His documented employment history listed him as a retired logistics consultant. He drove to the Providence storage facility 4 times in the 9 weeks of surveillance. Each time, he stayed for between 45 minutes and 2 hours. Each time, he left alone. The agents did not approach him, did not flag him, did not run his plates in a way that could be detected. They watched. On his 3rd visit to the Providence facility, in week 6 of the surveillance, Arvaneh arrived carrying a laptop bag and a cardboard box roughly the size of a shoebox. He stayed for 1 hour and 19 minutes. When he left, he had neither item with him. The box and the bag remained inside. The agents noted this. The contents of that box were not confirmed until the raid in March, when agents recovered a secondary set of shipping documents inside the Providence storage room, printed on plain paper, unsigned, listing component quantities, and a routing code that matched the freight consolidator's invoice format. The laptop was on the table beside them. Its contents became part of the digital evidence package processed after the arrest. What Arvaneh was doing on those visits, the case documents suggest, was managing the inventory reconciliation. He was counting what had arrived, comparing it against the procurement order, and updating the outbound shipping schedule. He was the logistics manager. Coram was the face. Arvaneh was the operation. Here is the part that does not make sense on the surface. The gyroscopes were not the only controlled item moving through the pipeline. The agents had been building the case around the refrigeration units, around the hidden coolant compartments, around the mislabeled invoices. That was the thread Nguyen's flag had started pulling. But in week 7 of the surveillance, Meade's unit intercepted a commercial invoice through a legal process that the case documents describe only as a lawfully obtained communication. The invoice was not for refrigeration components. It was for inertial measurement units, listed on the Commerce Control List under a different export control classification than gyroscopes. A related but distinct component. The case was not about one type of restricted device. It was about a procurement menu. Whoever was placing the orders was working from a specific list of components that together constitute the navigation and guidance capability of an unmanned aerial system. Gyroscopes provide rotational orientation data. Inertial measurement units integrate that data with acceleration readings to produce a continuous position estimate. Together, they allow a drone to navigate without GPS, in environments where GPS is jammed or unavailable. The war overseas is background to this story. The procurement order is the story, and the procurement order was specific enough to indicate that whoever placed it knew exactly what they were building. 267 gyroscopes, a corresponding volume of inertial measurement units, packed in commercial freezers, shipped through a freight consolidator in a neutral third country port, received by a front company in Worcester, Massachusetts. That is a supply chain. A domestic one, operating inside the United States, inside a licensed business, inside 5 retail stores that sold refrigerators to restaurant owners who had no idea what else their supplier was moving. Here is the take that will probably earn some disagreement. The system that allowed this to run for 14 months did not fail at the border. Customs inspected those refrigerators. The inspection process simply did not include opening the units. The failure was upstream, in the commercial import documentation review process, where 3 times market rate pricing on a component line in a freight invoice from a non-existent freight consolidator was never flagged. That gap is not a human failure. It is a procedural one. It almost certainly was not unique to this case. How many similar pipelines moved through similar gaps before Inspector Nguyen noticed a weld that should not exist? That question does not have a public answer. By the end of week 8, Mead and Ellard had enough for a warrant application. The application ran to 93 pages. It documented the mislabeled invoices, the surveillance observations, the Delaware LLC, the Providence storage facility, the connection to Arvanay, and the component classifications. It included the intercepted invoice. It included the photographic documentation of the unusual interior seam on the refrigeration unit at Conley Terminal. A federal magistrate judge signed the warrant on a Thursday morning in mid-March. The raid was scheduled for the following Tuesday. Before the warrant was signed and before the raid date was set, the investigative team spent 1 full day walking through every element of the case with the Assistant United States Attorney assigned to prosecute it. That meeting took place in a conference room at the Federal Building in Boston. The door closed, the case documents spread across the table in physical form. Mead had a standing preference for paper when reviewing evidence sequences. She said once, in a debrief document included in the case file, that paper does not autocomplete, and it does not suggest. You see what is actually there. The prosecutor, whose name is not part of the public record at this stage, raised one question that took the room an hour to work through. Could they prove that Arvanay knew the components were controlled? Possession of restricted items inside a leased storage facility is significant. But the prosecution needed to show knowledge and intent. The shipping documents Arvanay had been managing, the ones that matched the freight consolidator's routing codes, carried alphanumeric identifiers that corresponded directly to items on the Commerce Control List. A logistics consultant with Arvanay's background would have recognized those codes. The prosecutor was satisfied. The warrant application proceeded. But here is where the timeline compressed in a way the agents had not expected. On the Friday before the scheduled raid, a commercial truck departed the Polar Crest Worcester warehouse and drove south toward Providence. Standard pattern. Agents on surveillance documented the departure. They tracked the vehicle to the Providence facility. They waited for the driver to leave. The driver did not leave. He stayed inside the Providence facility for 6 hours. That was not consistent with any prior documented visit. Something was happening inside that building that did not match the pattern. The agents had a decision to make. Executing the warrant early, that Friday night, would protect the evidence. Moving before Tuesday meant compressing the logistics of a simultaneous multi-site operation. They had 5 Polar Crest retail locations, the Worcester warehouse, the Providence storage facility, and Arvinay's Framingham residence, to hit at the same moment. Letting one location go first, before the others were locked down, risked the entire network dissolving before the other doors opened. Meade called the field office duty agent at 11:47 p.m. The decision came back at 12:22 a.m. Saturday. They would hold until Tuesday. The Providence facility would be watched through the weekend. If the truck moved, they would intercept it. If it stayed put, the plan held. Put yourself in Meade's position at midnight on a Friday, watching a truck that should not have been there, with a 93-page warrant signed and ready, knowing that every hour was a risk. The patience required to hold the operation for 4 more days is not a small thing. The surveillance rotation that weekend involved agents working double shifts in unmarked vehicles parked in 2 different positions, covering the Providence facility's only exit road. They ate in their cars. They did not use the facility's surrounding streets for anything that could attract attention. The truck sat inside the loading dock of the Providence building, visible through a gap in the facility's corrugated metal siding, for 51 consecutive hours. The truck stayed. The driver left early Saturday morning. He drove back to Worcester. The Providence facility went quiet. Tuesday came. In the 72 hours between the warrant signing and the raid execution, Meade conducted a final review of the evidence package with Ellard and the 3rd HSI agent. They went through the surveillance logs, the invoice comparisons, the Delaware LLC records, and the intercepted invoice one more time. They were looking for gaps, for anything a defense attorney would use to argue the case had been built on inference rather than direct evidence. They found one area they wanted to strengthen: the connection between the alphanumeric codes on Arvinay's shipping documents and the specific export control classifications on the Commerce Control List. A forensic accountant on contract to HSI spent a day cross-referencing the codes against the official control list database and produced a 12-page technical addendum. It was added to the prosecution package the morning before the raid. March 17, 2026. 4:31 a.m. 12 federal agents from HSI and DSS, supported by a criminal investigative support team and local law enforcement liaison, moved on the Polar Crest Worcester warehouse simultaneously with teams at 5 additional locations. The Worcester entry point was the loading bay on the south side of the building. The door was a commercial roll-up, steel reinforced. The entry team did not breach it dramatically. They had a warrant. They used a key obtained through property management. The door went up at 4:31 a.m. Inside, 12 commercial refrigerator units arranged along the loading bay wall, identical to the units observed in earlier surveillance. Pallets of packaging material. Shipping manifests on a metal desk near the north wall. A computer terminal. The freezers were the target. Agents moved unit by unit. On each unit, they removed the rear panel using forensic tools that preserved the integrity of the modification for evidentiary photography. Behind each panel, the coolant system, standard. Behind the coolant plates on 8 of the 12 units, sealed polymer packages, wrapped in gray shock foam, labeled with alphanumeric codes. The packages contained gyroscopes. Aircraft grade, precision machined. Manufactured to tolerances that serve no commercial refrigeration purpose. 267 units across the 8 freezers. Photographed in place before removal. Cataloged with individual evidence numbers. The evidence photography alone took 2.5 hours. Each unit was documented with a forensic camera before any physical contact was made with the packages. The rear panel modification on each unit was measured, photographed from multiple angles, and noted in the evidence log with the specific deviation from factory specifications. The interior seam type matched the one Wynn had flagged at Conley Terminal 2 months earlier. The same fabrication technique, the same finishing method. The modification was not improvised. It was a standardized system, applied consistently across all 8 units that contained contraband, which means someone had designed it, manufactured the modified panels in volume, and distributed them. That process represents a level of industrial coordination that goes beyond what a small front company could produce internally. The panel modification was sourced externally. From where, the investigation had not established publicly by the time of the initial charges. The other 4 units were clean, empty of contraband. Probably the units that rotated into legitimate commercial deliveries to maintain the appearance of a normal business operation. On the metal desk, shipping documents for a pending outbound freight order, dated 2 days prior, addressed to the freight consolidator in the third country port. The order was for cold storage components. The quantity on the document matched the recovered units almost exactly. The shipment had been 72 hours from leaving the country. Simultaneously, at the Providence storage facility, agents opened a locked interior room and found the inertial measurement units referenced in the intercepted invoice. 41 units, packed in the same shock foam, same polymer wrapping, same alphanumeric code system. At the Framingham residence, Yusuf Arvaneh was taken into custody without incident at 4:33 a.m. He said nothing. The arresting agents noted in their post-operation report that Arvaneh appeared to have been awake when they arrived. He was fully dressed. The lights in the kitchen were on. There was a cup of coffee on the counter. Whether that was coincidence or indicated some level of anticipation, the case documents do not resolve. He was cuffed, read his rights, and transported without speaking a word. His attorney, a Boston-based federal criminal defense practitioner with prior experience in sanctions and export control matters, arrived at the federal building within 3 hours of the arrest. The attorney's familiarity with this specific area of law was noted in the prosecution team's case journal. It suggested that whoever was behind the operation had prearranged legal representation in anticipation of this possibility. At the Polar Crest offices in Springfield and Portland, agents secured business records. The Lowell and Providence retail locations were locked down and posted. No employees were present at any retail location at that hour. Dariush Khorram, the company's registered agent and the face of Polar Crest's public-facing operations, was not in Massachusetts. He was not in the United States. Khorram had departed Boston Logan International Airport on an outbound flight on March 14th, 3 days before the raid. His flight itinerary, recovered from airline records, showed a connection through a European hub to a destination in a country with no extradition treaty with the United States. He was gone. The raid had missed him by 72 hours. The warrant for Khorram's arrest was filed the same morning. The Interpol Red Notice followed within a week. As of the public record available through the date of this reconstruction, Khorram has not been returned to federal custody. One detail that stuck with me in the case documents: Khorram's departure was booked 5 days before the raid. He bought the ticket on March 12th. The warrant was signed March 14th, the same day he flew out. The timing raises a question that the investigation has not publicly answered. Did he have a reason to leave that week, or did he somehow know the window was closing? The case documents do not resolve that question. It remains open. In the days after the raid, investigators working backward through Khorram's travel history found that the March 14th departure was not his first time using the same European routing. He had made 2 prior trips through the same hub city in the 14 months since Polar Crest was incorporated. Both trips lasted between 4 and 7 days. Both coincided with periods when incoming freight from the third country consolidator was either delayed or absent from the Polar Crest manifest record. The inference the prosecution team drew from that pattern was that Khorram was traveling for operational coordination with whoever was managing the supply chain on the other end. The trips were operational. And on the third trip, he did not come back. Arvaneh was charged with conspiracy to violate the International Emergency Economic Powers Act, conspiracy to defraud the United States, and unlawful export of defense-related commodities. He appeared before a federal magistrate in the District of Massachusetts on the morning of March 18th. He entered no plea at initial appearance. Legal proceedings continued through the spring. The 267 gyroscopes and 41 inertial measurement units were turned over to a federal laboratory for technical analysis and assessment of their controlled commodity status. Analysts confirmed that the components matched specifications on the Commerce Control List under classifications that require an export license for any destination, including Iran, where such licenses are categorically denied under the comprehensive sanctions program administered by the Office of Foreign Assets Control. The components were not licensed. There was no license application on file. There was no application anywhere in the system under Polar Crest's name or any related entity name. The procurement cell had operated entirely outside the licensing system, relying on the concealment method, the mislabeled invoices, and the volume of legitimate commercial activity to move restricted goods without triggering review. The federal laboratory analysis went beyond confirming the export control classification. Technicians examined the physical characteristics of the gyroscopes themselves to determine their likely operational role. The units were precision fiber optic gyroscopes, a category that provides extremely accurate rotational measurement at low cost and small form factor. They are used in commercial applications, but the tolerance specifications on the recovered units exceeded what any commercial drone manufacturer would require. These were not off-the-shelf components purchased through a civilian supply chain. They were precision instruments ordered to a military-grade specification, and someone had written that specification before placing the order. The procurement order that drove the Polar Crest operation originated with an end user who knew exactly what tolerances they needed and exactly how many units they required to fulfill a production run of a defined number of finished systems. The technicians estimated, based on standard integration ratios, that 267 gyroscopes at this specification would equip somewhere between 80 and 130 complete guidance systems, depending on redundancy requirements. That is a production run, not a prototype, not a test batch. Does this have a version that a licensed import business could have prevented from the inside, or does the responsibility sit entirely with the federal export control review process? The answer has real implications for how these controls get enforced going forward. The Delaware LLC, connected to the Providence storage facility, was dissolved following the arrests. Its operating documents, obtained through the warrant, identified 2 additional names beyond Arvana as members. One of those names matched a person associated with a freight brokerage registered in a 3rd state. That brokerage was placed under federal investigation. The scope of that investigation is not public. The freight consolidator in the 3rd country port, the one whose invoices carried the 3 times market rate pricing, was identified in the case documents by description but not by name. Foreign law enforcement authorities were notified through appropriate legal assistance channels. The status of that notification and whether the consolidator's operations have been disrupted is not part of the public record. The employees who worked the retail floors of Polar Crest's 5 locations became a distinct concern in the aftermath of the raid. Most of them had been hired through standard commercial employment channels. They had no knowledge of what moved through the Worcester warehouse. They had sold refrigerators and prep tables to restaurant owners and cafeteria managers, processed credit card payments, scheduled delivery appointments, and gone home at the end of their shifts. Several of them, according to attorneys representing Polar Crest's former staff, had been with the company since its earliest months, recruited when it appeared to be a legitimate and growing business. When the 5 retail locations were posted closed the morning of March 17th, those employees arrived for their shifts and found federal notices on the doors. Some had not yet been paid for the previous 2 weeks of work. Their wages became part of the legal fallout of the asset seizure. The Little League sponsorship banner in Worcester Park was removed by the city within a week of the raid. The 5 Polar Crest retail locations were posted closed. Employees, most of whom appear in case documents as having no knowledge of the concealed component operation, were left in an uncertain situation. The gyroscopes never reached their destination. One customs inspector noticed a weld on the inside of a refrigerator housing. 3 words on a margin of a form. Abnormal interior weld. 9 weeks of surveillance. A 93-page warrant. A pre-dawn raid on a Tuesday in March. 267 components recovered. 1 key suspect in custody. 1 still at large. The procurement cell in Worcester is dismantled. Quorum's location is unknown. The freight consolidator that moved the invoices is still operating, as far as the public record shows. The Delaware LLC that connected to Providence had members whose full roles are still under investigation. And here is the thing the case documents leave open. Quietly, in a single line of the charging documents, the 267 gyroscopes recovered represent the confirmed portion of the Polar Crest shipment record. The confirmed portion. There were 63 commercial import manifests filed under Polar Crest's importer of record number. 14 showed the unusual routing from the third country freight consolidator. Of those 14, 8 yielded the recovered components. 6 earlier shipments, same routing, same consolidator, same time period, did not yield any recovered controlled components in the March raid. The case documents do not account for what those 6 earlier shipments contained, or where those contents went. The network's full procurement history is not reconstructed in the public record. Some of what Polar Crest moved may already be somewhere else. The case resolves where it can. The border was held at Conley Terminal on January 9th. The warehouse in Worcester was searched on March 17th. The charges were filed. The demand that created the procurement cell still exists. The gap in the commercial import documentation review process that allowed 3 times market rate pricing to go undetected for 14 months has not been publicly addressed. Inspector Nguyen finished her shift at 5:30 a.m. on January 9th. She went home. The case she opened with 3 words in a margin ran without her involvement for the next 9 weeks. She did not know, the morning she flagged that unit, what was inside it. She knew only that a weld on the inside of a factory-sealed refrigerator housing should not exist.